Remember, don't steal or do anything dishonest. Your government hates competition.
Anonymous News. As the world turns, what's new has our full attention. Join us to post what mainstream media will not. The truth. Australia, getting ready for the United Nations takeover. New World Order plans uncovered. In full, the complexity of it explained here. And also see links below if you do not want this read to you. It's your duty, if you truly care about our country, for your children to stop them from being enslaved by the corrupt. Please make people fully aware of this corruption forced upon us by the highly corrupt that do not have our best interests in mind. Please share this video and others spawn it everywhere. This is a long read but well worth listening to or reading it in link below. Prime Minister Julia Gillard has been charged with misprision, concealment of treason. United Nations New World Order instructed our government to suspend our constitution to allow their international New World Order United Nations laws to be enacted and treaties declarations to be implemented, which could only be done when our Australian constitution terms of allegiance clauses were erased or not active. Others, including judges, police, magistrates, public servants, pastors, media and reporters, who have contributed to concealing the fact of this action, are also charged with misprision. People don't realize. For any public servant to conceal, hide, or aid the crime of treason is to be guilty of the same offense. And these persons cannot hold any public office whilst under the charge of treason. New World Order plans uncovered. The New World Order are the world banking cartel who own all reserve banks. They control the world economy, they have the rights to print the money for all countries under the United Nations, and consequently they make trillions of dollars in fractional reserve lending, and they dictate the price of gold, making huge profits from the highs and lows, yet they pay no taxes, and own their own free sovereign states in England and USA with diplomatic immunity, at the Crown London and Washington, and the third in their circle of New World Order is the Vatican sovereign state. They reap in trillions of dollars interest daily from all United Nations member countries' government debts and are forcefully promoting more increased debts before wiping each government's control of the country out. To gain control over each government, their favorite MO is to provide bailout funds and to offer stimulus packages, all of which will never be repaid. Governments are conned to sell off their public-owned assets such as transport, shipping, rail etc. as the New World Order United Nations takeover can then take full control of these corporations without the need to gain public referenda approval. Unions are up in arms about these fraudulent sales. Governments are coerced into taking more loan money to use as stimulus packages to improve the economy so as to get governments into huge debts they will have no chance of repaying, preparing the way for the New World Order to come in and take over all assets. What's more, the Agenda 21 urges governors to sell off their assets such as railways, transport, shipping, insurance, water, power, banking, on the pretext that it will help reduce the huge debts. This is farcical, and the real reason is for New World Order takeovers, to gain easier control over private corporations than they would have with public-owned utilities, so it is to their advantage to get the government of the day to offload them before the New World Order takeover. This shows how gullible our government is to get duped by the New World Order rhetoric. We have been sold out since 1975 by all leaders in every government. We have only one chance to stop it. Keep pestering your member with these facts, and sever the United Nations treaties. Under treaties, the UN Charter, the United States Congress has established the Charter as the supreme law of the land. Fuji v. State of California, 1950-52, and all global member states of the United Nations including Australia have illegally sworn an allegiance to this United Nations foreign power, and to get any state to do this the United Nations instructed the Red Australian federal government to suspend the constitution, avoiding the need for a referendum. If you regard this as the most serious threat to Australian way of life and our freedom, join the new party, Australian Sovereignty Party, urgently. Following are just some of the policies of the United Nations: control of all zoning states matters in all member states, and the control of our national parks, rivers and historical sites, barrier reef etc. Control over whether women are allowed to have babies. Control over population. Control over all food sources. control over our farms, control over all land and property, control over the economic and judicial policies of all nations member states incorporated Australia. Programs are being processed to create a tax on citizens of all member states as a permanent method of United Nations funding. The fraudulent carbon tax is designed to fund the WHO, United Nations New World Order security forces. The United Nations has its own army, and United States soldiers and military from all member states must swear allegiance to this foreign government. Member states have been set up to roll over into United Nations control. So far these states are bankrupt, and the IMF will take over governance and initiate the IMF banking cartel's policies in Argentina, Spain, Italy, Portugal, Greece, more soon to follow, and Australia next. Subject matter: the grand jury process that has been activated by private prosecution right against Julia Gillard and others involving an organized attack on the Constitution of the Commonwealth and other state constitutions to impose a United Nations agenda upon all Australians. Grand jury process: the legal right to go before a grand jury in the state of Victoria exists at Section 354 of the Victorian Crimes Act 1958. To activate the right by private prosecution, Julia Gillard was charged with the common law offence of concealing treason. The charge was filed in the Melbourne Magistrates Court during December of 2007 and served January 15, 2008 at the Senate Street Werribee Electoral Office, returnable to Melbourne Magistrates Court on January 29, 2009. The others: on the 29th January 2009 there were other defendants also charged, in addition to 28 other defendants charged her December 15, 2006, all relating to the same offence. The problem: since 1984 there has been an organised concerted attack on all constitutions in the Commonwealth of Australia purportedly to achieve a republic, but, in reality to trap every Australian into a United Nations agenda without their knowledge nor consent. Fee simple titles: Queensland. In the state of Queensland a corporation has been set up to purportedly gather all fee simple titles into this particular corporation called the Brigalow Corporation. To effect this, certain laws have been altered or amended in Queensland to achieve this objective. The United Nations purpose: the United Nations has given federal government a mandate of ownership for housing, farms, property and business to government control, once the Republic has been proclaimed in Victoria. With total disregard to the Commonwealth referendum result held during 1999, the Victorian Parliament introduced a bill titled Courts and Tribunals Legislation Further Amendment Bill on May 24, 2000. The purpose of the bill was to abolish the Oath of Allegiance from the Legal Practice Act 1996. R. Hulls, Attorney General, Victoria. The bill was introduced into the Victorian Parliament by Mr. R. Hulls, the Attorney General for the State of Victoria. The bill did become an act without any referendum and full breach of the 1999 Commonwealth referendum result. Western Australia. On January 1, 2004 the Attorney General of Western Australia Mr. J. McGuinty, in agreement with the then Governor Mr. Sanderson, enacted an act titled Acts Amendment and Repeal Courts and Legal Practice Act 2003 WA. The purpose of the Bill Act was to remove the Crown and Her Majesty Queen Elizabeth, her heirs and successors and subjects from specific law within Western Australia in full breach of the 1999 Commonwealth referendum result. The Bill Act did not have any referendum authorising this legislation. All Attorney Generals in the period December 15, 2006 and January 29, 2007 when Julia Gillard was charged, all current Attorney Generals operating within the Commonwealth of Australia were also charged by private prosecution, after which the legal right to the grand jury process was also activated in relation to each Attorney General. Damien Bugg, Commonwealth Public Prosecutions. The Director of Public Prosecutions Mr. Damien Bugg was also charged with the other defendants, but Mr. Bugg sent an office delegate to the court to have his criminal charge dismissed with the other named defendants. The retaliation. Because criminal charges for serious indictable offences were filed against government officials, 2 Attorney Generals filed civil actions against myself to have their courts declare vexatious litigation in an attempt to conceal the grand jury process activated in criminal jurisdiction against themselves. The arrest. At the appeal full court the 3 Supreme Court judges, Styler, Bus and Christine Wheeler were informed from the bar table that the removal of both the Crown and Monarch from the Supreme Court Act WA was an act of treason, and as such the three judges were primary offenders, accordingly were placed under arrest from the bar table and formally charged for such offence in the Melbourne Magistrates Court, now pending grand jury process. Corryn Rayner, Supreme Court Registrar. Costs have been incurred in Western Australia involving the civil writ instigated by Magendie Bug against myself. Corryn Rayner was the registrar who heard the taxing issue relating to the Supreme Court costs. Corryn Rayner was murdered by persons unknown and her body buried in Kings Park overlooking Perth, Western Australia. Hull's Attorney General Victoria. To halt and delay the criminal process activated against specific government officials, Hull's, the Victorian Attorney General also issued a civil writ against myself to get his courts to declare Brian Shaw a vexatious litigant in the state of Victoria. His courts. I say his courts, because it was Mr. Hulls that introduced the bill now Act titled Courts and Tribunals Legislation Further Amendment Act into the Victorian Parliament, removing the oath of allegiance without referendum approval in breach of the 1999 referendum result. The order sought by Mr. Hulls was given by Justice Hanson, stating, Mr. Shaw can only file further process by leave of a court presided over by an Australian lawyer. Australian lawyer. For any person to sit in any court within the state of Victoria under the auspices of an Australian lawyer is to agree with the oath of allegiance being removed from the Legal Practice Act in Victoria, legislation introduced by Mr. Hulls himself. The appeal. The appeal of the Hulls writ was heard by Justice Dodds, Streeton and Nettle. Both were challenged for bias and after consideration continued the appeal hearing and upheld the decision of Hanson given in the civil judgment. Dodds Streeton, the defendant judge. The challenge of bias concerning Justice Dodds Streeton emanated from the National Bank writ issued against the Walter family. During the hearing of the Walter matter, Dodds Streeton did admit having a financial interest with the National Bank. When asked by Carmen Walter to stand down, Dodds Streeton declined, heard the matter resulting in the loss of $4 million worth of real estate at Wodonga, Victoria. Civil or criminal jurisdiction. The fundamental and basic principle of law activates that whenever and wherever indictable offences are discovered in any civil matter, the criminal matter takes priority over the civil. The criminal charges. The criminal charges lodged by myself and others involving and discovering serious indictable offences ranging from treason to judges hearing their own matters have not been withdrawn and remain pending grand jury process. Local government. If the United Nations agenda as revealed by Beasley's statement is to function within Australia, then local government must submit and agree to the United Nations agenda, which is the purpose of informing yourselves local government via this information. The three tiers of government are local, state and federal. Grand jury. The only competent and legal jurisdiction to hear the twin offences of treason and or misprision of treason concealment of is a sitting grand jury, 23 electors. This is stated law. It is provided now that all the prosecutions shall be by presentment, but preserving the prerogative of the Crown through the Attorney General to proceed by information, except in case of treason which has to be by indictment. Now indictment means by grand jury, and therefore, inasmuch as the statute provides that treason shall be tried by indictment only, that means that it must be by grand jury and no other means is provided for bringing it before a grand jury. The finding of the Attorney General is equivalent to the findings of the grand jury, but in the case of treason it must be the finding of the grand jury. Byrne v. Armstrong 1899, 25 VLR 126 at 132, the application. Any application applying for a grand jury hearing in the state of Victoria under Section 354 of the Crimes Act 1958 Vic must be heard by the full court, not appeal court of the Supreme Court of Victoria sitting in criminal jurisdiction. The sitting judges hearing the application against the named defendants are limited to hearing the charge only. They are unable to enter into the evidence of the matter. Such jurisdiction is the exclusive jurisdiction of a sitting grand jury. The Section 354 does not place upon the full court the task of examining the evidence, nor of determining whether the prosecutor has established a true bill. The section bearing the interpretation, which was placed upon it many years ago, which has never been questioned by Parliament, gives the full court a limited role which is no more than we have described. It requires no more than an affidavit complying with the section, disclosing an indictable offense. Lorne Campbell 1986 BC 862-28, The Perverting Process Freemasonry. In the year 2001 Carmen Walter and myself the plaintiffs attempted to issue a civil writ against Freemasonry Victoria. The writ was refused by the Supreme Court prothonotary under verbal instruction of Justice Beach. Following the refusal of the civil writ, an application was lodged with the full court of the Supreme Court Victoria. The actual hearing. The events surrounding the actual hearing will be correctly placed into a separate affidavit, but I will state in the correspondence to yourselves that the only intent of the full court of the Supreme Court 5 judges was to have the Byrne-Armstrong judgment overturned because it stated that where the affidavit reveals an indictable offense the court has no discretionary power but to order the sheriff to form the grand jury. Respect for the Constitution. Clearly there is now no respect for the Constitution of the Commonwealth or states, rather the constitutions have now been overlaid by a massive corporation structure, inclusive of the Supreme Courts and High Court. Your responsibility. You have now been formally informed of serious indictable offenses. You can choose to do nothing or you can choose to do something. The first thing that you should do is gather all relevant or actual facts. My responsibility. If you wish to be fully informed of the relevant facts inclusive of your legal responsibility, I will make myself available to answer any of your questions. The alternative. The alternative is to be summoned to a grand jury hearing and be placed into the witness box and be asked, what did you do after receiving the correspondence revealing treason and the concealment of treason? Legal advice. If you wish to seek legal advice, please advise the law firm giving the advice in writing that the oath of allegiance has been removed from the Legal Practice Act in Victoria by legislation introduced into Victoria by Mr. R. Hulls, the current Attorney General for the State of Victoria during May 2000. Competent jurisdiction. The only competent jurisdiction to hear and determine the evidence in relation to the twin offences of treason and the concealment of treason is a grand jury. An indictment for such offences can only be obtained from a grand jury. The Sheriff and the Queen. The words of the application order, he sheriff is ordered to summons the grand jury to appear at a court to be holden at a time and place determined by the court in accordance with the provision of Section 354 of the Crimes Act 1958 Vic to attend at such court at that time and place to inquire present do and execute all things which on the part of the Queen shall then and there be commanded of them. What is most disturbing by a handful of lawyers, judges, magistrates and politicians is the fact that they are firstly Australians. How dare they take such secret, covert and treasonable actions when they should be firstly protecting their own families, their own constituents, their own fellow Australians, and their own country. The Anzacs fought and died for their freedom and fought for our country to be in our own hands to prosper, not to be in alien United Nations New World Order bankers' selfish hands, particularly as they are trying to be the self-appointed rulers of the earth directing our government to enslave us with draconian laws. Your corporate-owned and run government working hard to protect you. Itself, from you, please help, share this article with others, see links to this below, thanks.
The heroic fight with us. The honest support us. The corrupt fear us. For we are anonymous. We are legion. We do not forget. We do not forgive. Expect us to expose you.